Yes, Your Honor.
What is the proper pronunciation of your client's name?
Um, I'm gonna pass on that.
Okay, understood.
I'm gonna take a guess and say it's Jermaine E. Sanchez or something like that.
Some of us call it
That
Mr.
sounds about right.
Sanchez.
Yeah, just call him Mr. Sanchez. That makes it much easier.
Did we perhaps also not have the budget for a gavel? Does that not?
Can we get someone to run down to the local Dollar Tree and buy a gavel?
Also, I made a request that I be given the first 2 minutes before questions are asked to me so I can lay out the case. Would that be fine with the panel?
I mean, I'm fine with that.
Oh, amazing! I was
Um,
just delivered a gavel. That's amazing.
I mean, is that okay? First 2 minutes for me and opposing counsel to lay out our cases, and
Yeah,
then
please go ahead.
okay,
Yeah, that's fine.
and then you can ask after that.
Time. Change date and time. There we are.
State, has your Solicitor General had time to appear?
Nope. We can proceed without him.
Okay.
Is the time correct on the thing? 20:07. Is that right?
Uh, yeah, 2007.
Oh, that's fine. There we go. I'm ready whenever you guys are.
Yeah, we're giving both parties a few minutes to
Okay.
clarify their cases and prepare as they need.
Oops.
So can I go up now because I'm the appellant, or
The court hasn't been called into session yet.
okay? I didn't think so.
If I felt that,
Hello. I keep on falling into the map by accident.
except for I have to meet with the dean on that, which I will do. I know the dean had more questions about her test than I had about mine. So all of them are pretty much done. The prepare plan for GAP, students support readiness by the first day. But it will be
Honorable Christian Parker, we can hear you by the way.
I have to meet with the dean.
Okay. Honorable Borgia, you ready?
Yes, I am, but do note if you call everybody to rise, I will not be able to rise.
I'm sorry.
I have a crippling condition called free cam.
Umpire, can you get behind the bar, please?
All right, Ace, Toddy, are you ready?
Yes.
Eight
All right, is the bot 8 already?
Mhm.
Okay.
All right, come to order. The Florida Court of Appeals is now in session. Today we're here hearing presented oral arguments in the case of the state of Florida versus Jermaine E. Sanchez. May we have counsel identify themselves for the record, please?
Jace Woods for defendant appellant.
Marvin Capri for State Florida.
Thank you. Good evening, gentlemen. Again, we're here to hear oral arguments. My apologies on the scope of the argument today with the state of Florida versus Mr. Sanchez. So the things we're determining today in today's oral arguments is whether the arrest warrant issued against Mr. Sanchez meets the constitutional statutory requirements for probable cause, and we're also determining at this oral argument whether or not executive conduct undermined judicial independence or due process, and other remedies sought by either party. Are both parties ready to proceed?
Yes, Your Honor.
Your Honor.
Before we begin, just conduct first, starting during the oral arguments. Each party will be granted 8 minutes of argument, okay? Each party will be granted a rebuttal between 1 to 3 minutes, variable on the decision of this panel. Interruptions, mockery, or personal comments will not be tolerated under any circumstances. If there's any misconduct or unprofessionalism, your behavior will be referred to the Board of Ethics, and you may be held in contempt. Does all parties agree and wish to proceed?
Yes, Your
Yes,
Honor.
Your Honor.
Alrighty. The court does understand Mr. Jace. I'm sorry, Jace. Mr. Woods, correct? Or are we going about that?
Mr. Woods, sir.
The court does understand Mr. Woods wishes to proceed, has requested a 4-minute opening. Does the state wish to waive that and allow Mr. Woods to proceed?
Yes, Your Honor.
All right, Mr. Woods, the court does allot you 4 minutes. You may begin. Are you ready?
Okay, I'm just going to sit down. I don't know. May it please the court. I'm Jace Woods. I'm counsel for Mr. Sanchez. Today, before the court, is a very serious issue. The state has alleged that my client has committed I believe it's conspiracy to commit murder. Their evidence, which was for just the arrest warrant, which is a very threshold issue at this point in the proceeding, is a bunch of unauthenticated screenshots taken from a Discord server that the state alleges belongs to Scream Services, which is a business that is owned and operated by members of Scream, which is this organization of people who drive black cars around Fort Lauderdale. I represent that group, but in this case, I represent Mr. Sanchez in particular. They allege that Mr. Sanchez paid $4,000-ish for a KOS service. And they allege this by using screenshots from an alleged Discord server that they allege belongs to Scream Services. The main problem that my client has with those screenshots is that they have not been authenticated, Your Honors. No one has come to the trial court, and said, I took this screenshot, this is true and accurate. They didn't do that. And also, there is the problem of just the bare minimum for probable cause. The question always is there a prima facie case of guilt, as found by the United States Supreme Court in Gerstein v. Pa? That is not readily obvious here. The court cannot give weight to some screenshots. In this day and age, where artificial intelligence can be used to generate banking statements, to generate all kinds of evidence, it is not simply enough in this day and age for the state or anyone to base a warrant based on a screenshot, which could be easily manipulated, which could be easily generated by artificial intelligence. Moving on to the second issue of executive conduct in this case. As the court is aware on the record, the governor has been co-representing the state along with my friend, the Attorney General, and he has been, in the view of me, in my capacity as an attorney and counselor at law and as an officer of this court, has been pressuring the judge in this case and the trial court to basically find probable cause. Originally, on the record, the trial judge found that no probable cause was present, and that was his decision after probable cause was contested by myself on behalf of my client. And then after argument and the governor intensely pressuring the judge to go his way, he suddenly changed his mind. This proceeding has been tainted by the governor of this state, not respecting a coordinate branch of government. He should be held in contempt, and we will move that before the trial court. However, this court must immediately vacate the arrest warrant, and it must immediately order the disqualification of the judge below, because this proceeding has been tainted by the governor. And the only remedy for that is to quash the arrest warrant, have the trial court issue a summons to my client to appear and answer, and to proceed to preliminary hearing where a different judge who is unbiased, who is not pressured, who has neither fear nor favor, can make a readily good determination of whether that probable cause exists, free of intimidation, free of threats, and free of an overarching governor and an overzealous executive branch. I welcome the court's questions.
Yes, thank you, Counselor. Just for me, my question is the evidence that was submitted by the state. Did you have an opportunity to view that evidence prior to the arrest warrant being issued?
No, Your Honor, not to my knowledge.
Okay. Have you, so till this day, you have not had an opportunity to view the evidence, correct?
Oh, I have seen the evidence, Your Honor. That was when I was added to the case chat. And forgive me, Your Honor, I can't exactly remember when that was. I want to say that was after the warrant was issued, I believe, Your Honor, but I could be very much wrong.
Got you. And based on the probable cause or sufficient evidence, do you believe, based on that, that a crime was being committed, or that there was evidence to substantiate the charges that were filed?
Would you like me to take the state's case entirely as true for the purposes of that question, Your Honor?
It's just a simple yes or no. I mean, based on the evidence that has been reviewed, is it in your opinion, in your legal opinion, that you don't believe there's enough probable cause for the arrest warrant to be issued? Is that correct?
That is my legal opinion, Your Honor.
Okay. And my second question, before this case coming to the Court of Appeals, usually cases like this, you will argue, probable cause in a preliminary hearing. At the preliminary hearing, that's when the probable cause will be challenged, and then the circuit court judge or the county judge, whatever is there, they will hear the preliminary hearing and base if there's enough probable cause for either to quash the warrant or to allow the warrant to continue to mine all of those charges over. So I guess my reason was, what was the reason for directly filing it to the Court of Appeals versus going through the preliminary hearing and argumenting that way? Because right now it just seems like a lack of jurisdiction here at the Court of Appeals, but I'm open to hearing your response to that.
Your Honor, the court below issued an arrest warrant to deprive my client of his liberty. And in doing so, they already found probable cause. And as we've previously argued, that finding is probably more or less flawed. To subject my client to being thrown in jail for however long until he can be heard before a judge for a preliminary hearing that is based on a potentially unconstitutional arrest warrant and an unconstitutional finding of probable cause. I mean, if they issued a summons, we would not be here, Your Honor. Not at all. We would be at a preliminary hearing right now, in fact, Your Honor, and we would be getting a determination of probable cause. However, the state went the arrest warrant route because they are trying to get my client into jail, because they are trying at every turn against Scream and its members. My client is a member of Scream, and their never-ending legal saga to destroy Scream by any means they deem necessary. That is why we're here. It is not because of my client. It is entirely because of the state. If the state was more reasonable, knowing that my client was represented by counsel, they could have had the court issue a summons. But instead, we're here because an unconstitutional deprivation of liberty is pending. If this court rules against my client, he's going to be arrested. And then the court may take a week, they may take 3 days, they may take a month until the preliminary hearing. In the meantime, I don't think that my client should have to sit in jail in on an unconstitutional arrest based on a flawed finding of probable cause. That's the whole reason why we're before this court. I don't think that it is right for me, in my capacity as an attorney, to say to my client, sit in jail for a month on a flawed finding of probable cause. I just don't think that's acceptable, Your Honor.
Understandable. I'm just gonna, I guess, just more of a statement. Here in the state of Florida, as you know, and as any other attorney knows, preliminary hearing, or as we would say, an adversary preliminary hearing, occurs after the individual is arrested, and it's usually within 48 hours, unless a judge has already determined that probable cause has been established. So normally in cases like this, the warrant will be issued based on probable cause, and then a preliminary hearing would follow within 48 hours of the arrest. And then at that point, the defense or whatnot would have that opportunity to really argue or advocate for their clients on why the warrant should be quashed if you believe that there is no probable cause that exists. So again, I think I'm just a little confused on why the case was why was it filed in the Court of Appeals, my apologies, instead of following through with the probable cause, and then at the probable cause argue to where your client's case should have been dismissed based on lack of probable cause. So I'm just confused by that. But I sustain. Oh, go ahead. I'm sorry.
I'm sorry, Your Honor. I realize I may have not answered the question you posed before in the way that you wanted me to answer. So if I could have leave to answer your statement.
Go ahead.
Okay,
Please.
yeah. So the circumstances that we find ourselves in today are exceptional. The judge has been pressured by the head of another coordinate branch of government to do whatever he wants. In this case, that is to find probable cause to throw my client in jail. As it is established on the record, the governor is not interested in the law. He's not interested in anything but my client being in jail right now. That's all he's interested in. So he pressured the judge in this case, disrespecting a coordinate branch of government, to find probable cause, even though that same judge originally found no probable cause after probable cause was contested by me on behalf of my client. So while it might make sense to wait for the preliminary hearing in any other circumstance, it's not acceptable in this, because even if I file a suggestion of disqualification as permitted by Florida statute to suggest to the presiding judge, hey, disqualify yourself because you're biased, he could still say, no, I'm not biased, and then we'd have to wait until verdict to appeal to this court. And so, in those exceptional circumstances, an appeal must be heard by this court this early on, because otherwise, I have to go through the entire process, and then that verdict may be thrown out by this court, and then we have to start all over again. In the interest of judicial economy, this court should decide the issue of whether or not probable cause exists, and then decide the issue of whether or not executive conduct had a role to play here. And if it did, to order the immediate disqualification of the judge below, and to have a new judge appointed who is not biased and will not be pressured by the head of another branch of government to rule in their favor.
Okay. From my interpretation with that whole appeal, from what I'm getting here, you're getting more towards the fact of the executive overreach in the case and the procedural mishaps more than the direct mishaps of the warrant itself, correct?
I would say so, yes, because Judge Taylor is right. Probable cause can be contested in a preliminary hearing before a different judge. That's totally possible.
Does the court have any other questions? Honorable Parker, Honorable Tody. Borgia?
Yes. Just kind of follow up. Uh, was a preliminary hearing already set before this case was filed in the Court of Appeals?
Before, no. Well, yes.
Yeah.
To be honest, Your Honor, I couldn't answer a yes or no because I wouldn't know. But a preliminary hearing was set for today at 7 p.m. Central. So at the time of this argument, Your Honor.
Got you. Okay. That's all that I have. And any of my colleagues?
Honorable Borgia, do you have anything to add? Or anything?
No, not at this time.
Alrighty.
Is there
Thank you,
robots
Mr.
here?
Woods. I want to give the opportunity for the state to present any evidence, or if they have any. I'm sorry, not evidence. If you have any oral arguments you would like the court to consider as a rebuttal to the defense's statements that have been issued on the record.
I just want my time, Your Honor.
You do not wish to. You're waiving your rebuttal?
I'm waiving my rebuttal.
Affirmative.
Alrighty. So I guess we will go into a brief recess and we'll take all of the testimony that was provided here in this oral argument, and we'll reconvene here. I'll say maybe 5 to 10 minutes. We'll review the evidence and we'll give our verbal decision, and then we'll write it as a court opinion. Does that suffice, parties? Or
Yes, Your Honor.
Well, I have my time, so, Your Honor.
say that again?
Your Honor, will I have my time to give my oral argument tonight or not?
Yeah, I just asked you. You said you wanted to waive it.
Honorable Parker, he was waiving his time to rebuttal. He does have.
Okay.
No, I'm not waiving my oral argument.
I was under the impression he was waiving any testimony he wanted to put. Okay, Mr. Attorney General, you can proceed.
All right. Mr. Chief Justice, and may I please the court? They say
Do we have
that
order in the court, please, back there?
What exactly?
they say that. Your Honor, may I proceed?
Yes, proceed.
They say that this warrant was unconstitutional, unconstitutional this, unconstitutional that. You know what else is unconstitutional? Murdering people on the street, paying murderers to murder other people. That's absolutely absurd. We should not be condoning solicitation of murder in this society. The appellant paid Scream Services $4,000 to put a kill on site order. The previous judge that was presiding over the case, Honorable Tim Bradford, confirmed that KOS was an abbreviation of the term kill on site, and the kill on site order was put on FBI agents, law enforcement officers. A kill on site on law enforcement officers. That should not be allowed whatsoever. So when we talk about probable cause, there's more than enough screenshots to prove that probable cause did exist. The general requirement for text messages being used in court, and if they're admissible or not, is authentication. We did authenticate that the messages were sent by Jermaine E. Sanchez, the defendant, through screenshots. Multiple screenshots, one coming from the governor and another coming from, I think it was an FBI agent that joined that Discord before they're banned, before the owners of Scream Services banned them and covered up their tracks like they have with me too. They banned me from their Discord. I can't see any of their channels. Yesterday in Florida v. Jermaine E. Sanchez, you can see that I sent 2 screenshots. One was of him paying out Roblox for days 5, 6, 8, 4,000 and economy money. He filled out the format, Roblox username, there, the name on the hit, and the reason and the cost. The reason was because they are a part of FBI and there's personal motives before that. what else? And the defense did say that there was no authentication in the screenshots. The governor himself joined that Discord and took a screenshot, and you can see the defendant's full Discord profile. I will forward the evidence in the channel once more if you guys want to see it. So it does meet constitutional and statutory requirements of probable cause. The messages were authenticated. What else? Did executive conduct undermine judicial independence or due process? No, it did not. Me and the governor and the Solicitor General and any other members of the state only wish for people on our streets to stop getting murdered. I don't think that's too much to ask for, is it? We do not want our law enforcement officers cold-blooded murdered anymore. So we went into the Scream Services Discord and we took screenshots. We authenticated those screenshots and recreated a warrant. Only wishing for this person to have a warrant out for their arrest and for that warrant to not be stayed or invalidated in any means is not pressuring the courts. If I speak on behalf of the governor, if he did in any way at all pressure the courts, then he'd like to apologize, and I'd like to apologize too, and I'd like to apologize on behalf of my Solicitor General. We never would wish for any of that to happen, but I'm now open to questions from any of the justices.
Yes, I just have a follow-up question. So, was the reason probable, in your opinion, as the Attorney General, did you request a warrant based off of the probable cause due to the screenshots with possible incriminating evidence that suggested the defendant did the screenshots that you believe that the defendant was going to commit a crime or was in the process of committing a crime?
Yes, so the exact criminal statute is statute 77704, attempt solicitation and conspiracy. So if you pay someone to murder someone, that is a violation of that statute. And that's what the defendant did.
Got you. And is that the charge he's charged with for the statute 707.4?
Yes, Your Honor, nothing more.
Alrighty. And do you feel like there was sufficient evidence to file charges based on that Florida statute with all of the evidence that was presented?
Absolutely, Your Honor. We double checked it.
Did the governor attempt to influence the presiding judge's knowledge or try to persuade the presiding judge in the case to rule in a bit of an unorthodox way?
I do not believe for a second that the governor, in all his wisdom, would try and influence the ruling of the courts in any way whatsoever.
Okay. If you don't mind, Attorney General, just one question. That evidence that was provided to the court, was there an attempt to, or at any point, was a sworn affidavit and or testimony provided to the court backing the validity of said evidence?
For an affidavit, we did not have the time to gather an affidavit. If in the actual trial, I would absolutely reach out for an affidavit on the person who took the screenshots, but no, we do not have an affidavit at this time.
Okay, and was any proof of validation provided to the courts regarding the warrant?
So when the defense counsel began arguing that these could be false screenshots, I asked the governor if he could just join the Discord of Scream Services and take more screenshots of the Kill on Site request channel, and the message was still the exact same, still same date, wasn't changed. In the first screenshot that we sent, the one with the dark reddish background, that was the defendant's profile previously, but there is a new one with his current profile on it. So yes, it was authenticated.
Understood. Do any of my acquaintances here have anything to add? Questions? Okay then. Would the defense like to secure their time to rebuttal?
I would love to, Your Honor.
So you may, if the defense would be seated back at their. Thank you. The
Okay.
court recognizes the plaintiff's counsel. Pardon me. Defense's counsel. You may go ahead.
Your Honors, it's the same story that it has been from day one of this entire legal saga against Scream and my client included. The state got tunnel vision, and they're urging this court to ignore the law, to ignore legal procedure, to ignore pretty much common sense, to give them carte blanche to go after my client and Scream and everyone else involved to the maximum extent they possibly can. And I note that my friend, the Attorney General, apologized for him and the governor for any inference of pressuring the judge in the lower court. However, even though they have apologized, that is simply not enough. They have disrespected a coordinate branch of government. They have pressured a judge who holds their office for life and threatened to remove him, I'm pretty sure. I could be wrong. You'll have to check the record. And also, there was no sworn testimony or affidavit submitted to support the arrest warrant. The statute governing arrest warrants very much requires a sworn affidavit. That is the strict text of the statute. That's what the legislature envisioned, and that's not here. And also, the Attorney General goes on about how KOS allegedly means kill on sight. That's not in the record. It's nowhere in the record. It was a judicial finding of fact that was not supported by anything in the record. It should have not been made. It should be tossed out and voided because it's not supported at all. KOS, according to the dictionary, means an island off of Greece. If it means something else, the state has not proven that whatsoever. They haven't filed like an affidavit. They haven't filed nothing. So KOS means an island off of Greece, for all this court can know. And he goes on about how they submitted screenshots and how he asked the governor to go into the alleged Discord server, which may or may not exist, we don't know, and take screenshots that incriminate my client. Your Honors, right now, I could go to ChatGPT, and if I dial in the input just right, I can generate those same screenshots. Every single one of them, I bet you. And if I can do that, screenshots don't mean nada, because they can't be trusted, they can't be relied upon, and they're inherently unreliable. They can be faked, they can be edited, they can be generated by artificial intelligence. And no credibility can be given to the governor's vouching of, oh, these screenshots are, correct. He didn't even say that on the record. He just took more screenshots. No credibility can be given because of his prior conduct. To use a legal doctrine of when the witness lies on the stand about one thing, his entire testimony has to be considered a major lie. I forgot the formal Latin for that. Go ahead, please.
Pardon me if I could stop you there. You did use up your 3 minutes. Unless the plaintiff, the state, would like to yield time to you for you to continue, I think it's only fair that we.
Questions.
No, we would not like to yield.
I have some follow-up questions
Okay.
regarding the what was just said. Mr. Woods.
Yes, Your Honor.
Are you implying or accusing the prosecution's counsel of faking imagery?
I am not accusing that. I am not accusing them of that, Your Honor, and I would like to respectfully refer you to Model Rule of Professional Conduct 3.1. A lawyer for the defendant in a criminal proceeding may require that the state prove by each and every element of the offense, or in this case, of the probable cause for the warrant, I may require them to prove each and every single element. So I have not alleged that the state has faked anything. I'm simply requiring them to prove each and every single element, as I am ethically obligated to do and allowed to do.
All right, and are you aware that evidence was submitted to the court case at 9:33 p.m. with an attachment from the alleged evidence that and I'll just go and quote it. Let's see. A KOS is similar to our Hitman service except is cheaper. When requesting a KOS, you're requesting for, instead of us targeting and looking for them, you're looking for him, but for all us to kill on sight. In other words, for us to kill them if we see them. This was submitted last night, approximately, I'm not too sure, my system time changed, so it may be 9:33 in the afternoon for Eastern Standard. Are you aware that that piece of evidence exists within the court?
I am aware that a screenshot was submitted containing that information. However, they have not authenticated that screenshot. That screenshot could have come from anywhere. And even if, and I don't encourage the court to do this, but even if we take their entire case as true on that screenshot alone, that still doesn't amount to anything. That's still, okay, so KOS is similar to Hitman services. Still don't know what KOS means in the record below. Whether or not that could be further developed, we'll have to see. But on the current, the court is confined. This court is confined to the record that currently exists. And this record does not support any sort of inference that KOS means anything else except what the dictionary says it means, which is an island in Greece, apparently. And Your Honor, I'm sorry. I would like to just put on the record, for the purposes of this proceeding to be used in the trial court, that the governor came up here next to me and accused me of lying and said I'd have to get off the stand or I'm going to be removed. And I have a screenshot of that, and I'm just placing that on the record for the trial court to deal with.
Yes, we'll address Governor Capri's actions a bit later.
Yes, Your Honor.
I will be sending a piece of evidence in the 4th District Court chat. I would like you to read off what is said in that attachment right there. And, well, I actually have 2 questions.
If you could give me a second to get over there.
Yes. Is this a piece of if you recognize the piece of evidence, and B, do you mind reading off for me what exactly is that? Oh, did he kicked himself off the stage by accident? Yeah, I'm working on it.
Apologies, Your Honor. My internet doesn't particularly like me right now. Where is this the screenshot you sent at 7:43 p.m., Your Honor?
Yes. Are you aware that that piece of evidence exists?
I wouldn't call it evidence, Your Honor. I would call it a screenshot. But yes, I'm aware it exists.
Yes, it is. It is obvious. Okay. So you are aware that it exists within the chats, correct? Within the.
Yes, but it hasn't been authenticated. It could have been generated. It could have been. We don't know. We don't know anything about this screenshot. It just exists. It's not evidence, I don't think. It can't be considered evidence. It hasn't been authenticated.
Okay. That's all I have.
My rebuttal.
Your Honor,
Would the panel like to distribute time for a rebuttal to the rebuttal?
Your Honor, that's.
I mean, you're accusing us of some frivolous claims. I don't know if we can.
Let's not. Would the court like to do that?
Whoever's flying
I've
around
heard
needs to
it.
be kicked. I'm tired of seeing people flying around.
That was the bailiff.
Okay.
I'll repeat it once again for the panel. Would we like to allow a rebuttal to the rebuttal out of?
I would like to.
You would like to?
Yes.
Honorable Parker.
I would not. I've heard enough.
Plaintiff, what would your rebuttal consist of?
It's addressing how these accusations on how these screenshots are, I wouldn't say allegedly, implying that these screenshots could be fake.
Who dragged me?
So,
I'm gonna go ahead and side here with Honorable Parker. I don't think we need to hear any more regarding that.
All right, but still, who dragged me into the Florida Supreme Court stage?
I don't think we're getting an answer to that question.
All right, well, somebody dragged me into the Florida Supreme Court stage. All right, works for me. Whatever.
Panel, would we like to assign a 5-minute recess to come up with some decisions, and then we can decide if we want to rule or not, and
Yeah.
allocate some additional time for that?
Yes.
Okay, so at this time, the court is going to be entering a 5-minute recess. Everyone may stand. Let's head back here. Come on, guys.
Private office one.
Requests as designated per our scheduled time.
No, Your Honor. I would like to submit for a decision order.
Affirm. Plaintiff?
What do you mean procedural remedies, like topics? Could you elaborate?
Anything my apologies. Anything relating to the procedural errors or lack thereof in this case?
Oh,
Any remedies
Your
of
Honor.
such? Okay. Well, the court has come to a ruling. We will issue a written majority ruling, which is unanimous, 3-0. Shortly after, but we will give our verbal ruling as of now. Toady will speak first with the issue on the warrant.
Oh, perfect. Just want to take a bite of my food. All right. 1 second. All right. The warrant issued by the 17th Circuit Court is hereby quashed and is remanded to the lower 17th Circuit once again, under the condition that the state refiles with an affidavit and a preliminary hearing is successful. Warrants under the Constitution and Florida statute require sworn affidavit, and such shall be done in warrant request with a new format.
Do plaintiff and defense recognize?
Yes, Your Honor.
Yes, Your Honor.
Moving on to the second topic, Honorable Parker.
Thank you. But this court has found the Governor Capri, in indirect criminal contempt of this court due to unfairly influencing the proceedings in Florida versus Jermaine Sanchez. Subsequently, this court orders a 2-day incarceration period with a $1,500 fine. Governor Capri is to turn himself in to the Broward County Jail by Friday, 6 p.m. midnight Eastern Standard Time to complete his 2-day incarceration period.
Do both parties recognize?
Yes, Your Honor.
Yes, Your Honor.
And finally, the last decision of this court and its verbal issuance is that the Honorable Tim Bradford is released from Florida versus Garmain Sanchez. A new impartial judge will be assigned to ensure fairness of the proceedings. The Honorable Tim Bradford will not be dropped from the judicial applicant program, but will instead be reassigned to a new case. Do both parties recognize?
Yes, Your Honor.
Yes, Your Honor.
Do either party have any questions?
No, Your Honor.
No, Your Honor.
Bill, you have a question?
Come up on stage and say your question.
He may not be able to.
Let's get in the stage, VCville.
Your Honor, I would like to take this opportunity to object for the record. He's not a party to this proceeding.
Sustained. Bailiff, can we get him out of here? The court recognizes Vil is not a member of these official proceedings from any party. Can the bailiff please handle him? Oh, whoa, whoa! Bailiff, bailiff!
I move to hold Vil in direct criminal contempt of this court.
Ah!
No! Oh my god, he dazed two judges. Okay.
Your Honor, I would still insist that my motion be ruled upon, please.
Pardon the panel. What?
Oh, okay.
Can you repeat?
I would like to hold Vil in direct criminal contempt of this court for what he just did.
Does the panel concede?
Yeah, concedes.
No objection here.
I concede as well. By issuance of the 4th District Court of Appeals for direct criminal contempt of this panel and this court, Vil is found in once again direct criminal contempt of this court. This 30-day incarceration period sound to everyone, or should we go much higher?
Are you asking the parties?
No, sir. I'm asking my panel since we're not
So-
convening.
I don't know how long is constitutional. I'm assuming I can't just say life sentence, obviously. So I mean, I don't know, 3 weeks or a month. I don't know.
Well, yeah.
Well, I would say 30 days. 30 days.
I conceded 30 days as well.
And 30 days works for me.
Okay, to 30 days of incarceration in the Broward County Jail. Do both parties recognize?
Yes, Your Honor.
Defendant?
Yes, Your Honor.
Any questions for this panel?
No, Your Honor.
Plaintiff?
No, Your Honor.
And with that, this court session is hereby adjourned. Court additionally reconciles that a written statement of the majority ruling will be issued shortly within maximum 1 24-hour period.
Thank you, Your Honor.
Why don't we just
Okay, well, the Attorney General is no longer here for me to shake his hand. Okay, well. Alright.
Okay, that last part was not thought out, but that worked, I guess. I think the people have some questions. I don't know what's going
Are
on.
we allowed to take questions? I mean, we did just.
No. Oh my
No.
god. No, we are not. But oh my god.
Yeah, I should have.
Bailiff,
held
I'm
the
starting to wonder if we should hold. Yeah, I'm starting to wonder if we should have held the bailiff in. 30, can you get back here? I don't think it's secure over there. Whoa! Let's not do that.
Okay, well, I want to go home and eat.
Yeah, let's all go.
20 pathetic $1.
Today's proceedings
There's
have
a
already.
15-pound bomb under your car.
Okay.
Bomb our
Yeah,
pizza
today's
butt.
proceedings are done. Everyone get out.
Everyone get out.
I got sent a video of the dude who jumped the cage at the one lady. He heard a sentence and he like jumped over the wall to attack the judge. I got sent that gif. It's low-key kind of funny. It's a little hee hee ha ha. You should do a news story about that. Be kind of funny.
I'm honestly, I'm pushing to do news broadcast after this because why not? But I need somebody who's in PR to do that. Well, we started.
Uh-oh.
Hey, Toady.
What? Bye. I guess not. Perfect.
Eek.
All right. I'm gonna go into the Broward 5 Media channels because why not? Y'all want to talk in there, I guess. Oh, I do need to assign a new judge for that case, huh?
I'll do it.
Okay.
What's up, chat?
If I could,
I'll do it. I'll give it to one of the judicial applicants. I know what other must want. they've been wanting it to do it, so I'll do it to one. I'll give it to one of
I
them.
was gonna suggest somebody, Mr.
I'll give it to Joel.
Perfect. We're like, we don't even have to communicate. That's who I wanted to give it to.
Oh, eek.
Awesome, cool. Yeah, because I mean, we've gone back and forth before, so why not?
Yeah, this is gonna be one hell of a thing to write up. Tody, you're helping me here. You're
Yeah,
co-authoring this.
have fun writing that log, by the way, because I knew you guys got the log. Log that.
Well, we already have everything on the script mainly, so I mean, it's not that big of a deal.
Yeah.